Welcome, everybody, to this week's legal surgery. My name is Kinga, and I'm here with Alex Woods, civil litigator at Court Wingman, and the managing director. He will be here today to answer any questions and legal scenarios that you may have. So, if you are currently in court or are thinking about going to court, do tell us what stage you're at, what questions you have, or even if you don't know any of that, you could tell us what should you be doing next. Alex, do you have any remarks before I pass the form to everybody?
Yeah, that we should try and put a list of all the topic subjects that we address, either in the vlog itself, which I think you might even be able to do, the video itself, or in the link below. It's not enough to just have the topics in the subject box. I think we do need to have a list of the topics up in the description box below at least, and the rough times, like 5 minutes in, 10 minutes in, 15 minutes in. I have just got two things that I wanted to talk about to clean up from last week. The first is that I actually rang the law. We had a question last week: how do I find a no-win, no-fee lawyer?
We did.
And it's quite a good question because it really is difficult to know. And a law firm might say, yeah, we kind of do it, and then they don't, or they check, or we don't think your case is strong enough or something. Probably they're really saying, we don't like doing no-win, no-fee. We just said we did in order to get your business. So you know what I mean? I've had quite a few cases where I'm just horrified at the amount of money that they've spent on lawyers, and they've got really good claims. We've got one now, but the lawyers before us have just flushed her out of money. They've cleaned her out. And so she's come to us because it's just gone round in circles. And we're prepared to do no-win, no-fee, because as a business, you need to be structured in such a way that you can do it, because you've got a cash flow long litigation. It's a risk. And solicitors are institutionally risk averse, you see. So this is all of this is why I think no-win, no-fee. Now, I went onto the Find a Solicitor page, which you can just Google and get on there. But you can't select by no-win, no-fee. You can select by sector, but not by type of retainer. So I phoned them, and I also sent in a form. You know, when you phone people and they go, "Oh, just send an email." It's like,
yeah.
Well, no. If I wanted to send an email, I'll send an email. You're saying to me, "Can you just go away, please?"
It really is.
So annoying. So I thought, I know what to say. I says, well, the thing is, I do a legal surgery for the British public online once a week. Well, maybe I lie.
Once every other week.
Can't remember. And I'm a solicitor, and I had a very interesting question last week, and I need to get back to my audience today. And that changed the tone of her response.
Did it really?
Yeah, it did. Because you just got to look at what, in life, you have to look at what people's agendas are. When you get old and ugly like me, you realise there aren't that many idealists and conscientious people who do things simply because they need to be done, the job needs to be done. The world is full of people who will only do things if it's in their interests, organisations especially. So you've got to find a way to understand their agenda. Now, their agenda is they don't want to be criticised by the public. The Solicitors Regulation Authority just seems to be there to bash lawyers when they get complaints from the public, or not bash them, but their agenda is to keep the great British public sweet. So the Law Society, I think, is a little bit like that too, although they are the body that's meant to represent and champion solicitors. And, they do. I've not had bad experiences with the Law Society. I've had good experiences with the Law Society. But like any corporation, you've got to find out what the agenda is. So when you say that, you do a legal surgery and you're online, and you may think we've got 1 million viewers like Joe Rogan.
That would be nice.
Yeah. Well, so that then gets them, and rather than get frustrated and start to go, rah, 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 why don't you do it? You've just got to accept that life is not, it's not an ideal universe, and you have to find ways and means and box clever. Anyway, I'm probably talking out of turn, because it'd be interesting to see whether they do get back to me, and also whether they actually add no win, no fee to their drop down list.
It would make
that's really
sense.
it would complete. It's more important than do you work in, commercial litigation or general litigation, or no, are you going to fight my case and take some risk, become a business partner with me, and work for no win, no fee? That's what I want to know. If I've got a big contested wills case or a property dispute and I've got no money, but I can guarantee you I own half a house, and I'll give you the money once I get my half of the house, and that case is a good one. So that's that. So thank you for that question last week. That's the follow-up on that. I just wanted to clarify double recovery for the building people out there, because building disputes are very, very common. And there's a very, very common problem, which is people don't particularize their losses accurately. Do you remember we talked about that? And then I said, so King, what's the answer? And you were like, hello, did someone just say my name? And you were like, you were too busy doing other producer things in the background and hadn't listened to my question. And then it got a bit confusing, I think. So just to clarify double recovery, what people often do is, here's an example. They have a builder in, the builder charges them. By the way, am I looking at the camera? Can you see my eyes?
I can. Yeah, why wouldn't I?
Because I've noticed that I look down there a lot, because I don't, I'm looking for inspiration, but I need to look at the camera. So a builder does a job for £1,000, okay, a kitchen conversion, whatever. He cocks it up. You've paid £500 to start the job and the £500 at the end, but you don't pay the second £500 because he's cocked it up and you've fallen out. Now, you get it redone, costs you £600. Are you paying attention, Kinga?
Mm-hmm.
So, what should the claim value be that you put into the N1 box on the classic typical Part 7 N1 claim form? You're claiming him, yeah. So what should the claim value be?
Man, I did not listen.
It's not your fault. I didn't make it clear. I didn't make it clear enough.
You should have been like, Kinga, listen right now. I was actually putting the form for the questions in the chat as you started the scenario. So then I thought, when you asked me, are you listening and paying attention? I thought,
all right.
That was just
anyway,
general
have a stab. Are you avoiding the question? What should the claim value be?
What's the work he did?
Right.
And
so £1,000 of the job, kitchen extension. You pay £500 up front. He cocks up.
Yeah.
You then don't pay the second £500. You have to then get someone else in to redo his damage.
Yeah.
To make it good, complete the job or whatever. But whatever it is, he might have left the job incomplete, or he might have done some damage you have to remedy. But the cost of that is £600. What should you put in the N1, the little box at the bottom? What should your claim value be?
Well, doesn't he actually just owe you like £100 because you haven't paid him in full?
This is exactly right. The question you should be asking yourself is, what are your losses? So you're not claiming £600, you're claiming 100. Now, it may seem simple to you when you have a very simple example like that, but you'd be surprised at how often people get that wrong. Particularly, it's a little bit more complicated. And the problem is, let's say the cost of redoing the job is £400, what should go in the claim value?
Well, then you can't claim that money, can you?
Exactly, but you may be so incensed by the damages done and so on, and you may be claiming for distress and inconvenience, and there may be a few little things, like he left his skip outside in the garden and done some damage, and that cost £50, and then there's the electrical meter that was missing and you had to pay £150, but then he says, no, I bought it, you just lost it. You need to those are all little things, that may mean you feel wronged and he's negligent and therefore you should bring a claim. But rather than focusing on all of that, you need to be icy cool and decide what actually is your claim value. And if it's only £100, you're probably better off not bringing a claim. Because when it gets to court, I mean, let's magnify the figures by 10, If that, when it gets to court, it may be just not have been worth it, and you may be in danger of losing if the judge says, oh, well, he did find it, he did give you the electrical meter and you just lost it. So he did buy that. So I'm going to make this discount to your claim value. And even though you've kind of won, because you didn't pay him the full for the job, this is a pointless claim and therefore costs against you. So that's why particularising the losses is so important. So I just wanted to clean up that issue on double recovery.
On that point, actually, in the book, you do a handy table, actually, on building disputes as well. Page 280, you lay out all the tasks that were done in this dispute and the value and the counterclaim value too. So you've got, let me zoom it in.
Wow, that's nice. And it's got some nice sort of grey sections as well, very nicely formatted.
A nice table indeed. So yeah, you've got a lot of on builders in the actual book. So if someone is actually struggling and they get it wrong, they really have no excuse after watching this live YouTube video, because we have mentioned resources.
Good. So have we got any questions? Have we got a potential what's the word, interviewee?
Okay, so no one again is brave enough to actually join us on Zoom, unless someone out there is listening to us right now and they don't mind jumping on our Zoom call, sharing their voice and talking about their dispute. If you don't mind doing that, do say in the chat right now and I'll give you the information on how to join us. In the meantime,
they could be, sorry, they could be nervous about me giving them a roasting, because that was a lady, I think, said that backstage, didn't she? But you know what? Yes, get yourself a roasting for free, because that's what's going to happen when you get to court. You will be bulletproof. Put you on stage, take the hit. It's a bit like taking the microphone at an event, and actually put yourself out there. And I'll tell you what, you will go into your hearing pretty much bulletproof, because you'll have had a bit of a dress rehearsal.
Okay, well, we have the following questions. I'll do the chat ones first and then we'll do the forms, because the form ones are usually a bit longer. So one person is asking, how do you protect yourself, or what insurance might protect a potential litigant in person from having to pay opponent's fees, if it exists?
Yeah, there is only one type of insurance, and it's called after the event insurance. That's a really good question, because a lot of litigants in person have this challenge of facing, particularly against a big bank or something, they have the problem of that bank is going to roll out its lawyers, even for a small claim, conceivably. Anyway, they're going to roll out their lawyers and they're going to intimidate you. Welcome to the real world. It's not about fairness and justice. It is a little bit, but most of all, it's about winning and being ready. So you have got a real, if it's a high value claim on the fast track or the multi-track claim, it's like a £20,000 missold payment protection insurance product. And they win in, and I'm talking from experience, they win in their big lawyers. There's a one set in London that is just basically owned by the banks. And all the barristers, nearly all the barristers, are bank barristers. And they just roll them out, send them to court, and the cost is astronomical. And if you're not careful, your little piddly PPI claim of 20,000, you end up with a 50 grand bill against you. I had a claim against Bank of America, MBNA, where I think we only won by £100, and we won £35,000 costs against the Bank of America for a good client and a good case that was complex. very low value. I think it was even only about £10,000, £9,000 claim value, but it needed lawyers and it was allocated to fast track. And, you know, she was lucky enough to have found lawyers like us who would do no win, no fee, and who could get after the event insurance for her. But unfortunately, the world changed a few years ago because the motor insurance sector put pressure on Parliament, and they changed the law so that now you can't get the cost of the after the event insurance from your opponent if you win. Like the general principle of civil litigation is the loser pays the winner's costs. So you sue a big bank, you have to take out after the event insurance, and obviously there's a cost for that. The cost is actually paid at the end. This is why it's called after the event insurance. And you win, and you would have expected 6, 7, 8 years ago, you would get the insurance paid by your opponent, whatever it might be, £5,000 or £10,000 or £2,000. But now the law's changed. You can't claim your after event insurance costs from your opponent, even if you win. So you've got to take it out of your winnings or somehow find the money for it, to pay it, you know, to cash flow as an expense of running the litigation. So same is true of the success fee in no win, no fee litigation, but we won't get into that. Now, so that's how after the event insurance works. It pays your opponent's costs if you lose. Interestingly, if you lose your case, you don't pay the insurance company anything. It's only if you win the case that you pay the insurance company. Because that's the whole point. Why take out expensive insurance and then lose, and then you have to pay for the expensive insurance? It's an interesting type of, very unique type of insurance product. But for litigants, the problem with after the event insurance, because you're a litigant in person faced with a big bank who've instructed the top expensive barristers to go to every hearing and draft all the pleadings, so they rack up big costs because they're doing that to intimidate you. The problem is the after the event insurer is not going to insure a litigant in person. I mean, I say that, I can't say that 100% for certain, but it's really hard for solicitors to get after the event insurance unless they're experienced and got relationships in the industry, let alone litigants in person, because the insurer will only jump on board and go with you and give you insurance in your case if it's satisfied that you have a genuinely strong chance of winning a large amount, and probably a largish amount of money, not 10,000, you know, more like 100,000 or 50,000. So that makes sense. Now, how do you convince the insurer that you've got a strong case? Well, you know, if I created a pile of all the papers and the cases and the clients who'd contacted me over the last 20 years with cases that they were like, Alex, this is a winner. It's great. We're going to win, mate. It's brilliant. It's a really strong case. I've got all the evidence, you know. If I count the number of those cases that, you know, you get burnt initially when you're a young solicitor by doing these cases and they turn into a nightmare. Oh, what, you wanted that document? You know, it is the critical document, and he gives it to you, you know, months into the case once you've already spent a lot of money and time on the case. And then you suddenly realize this is actually a weak case, not a strong case. So the after the event insurer is very cautious about that. And that's why they're not going to insure a litigant in person, probably, because they've got no track record like a law firm has. And after an insurance and go, oh, this law firm's good, it's done it, we've worked with them before, and they've got a track record with us of winning cases. Or now the alternative is you get a barrister to write an opinion on your case and give it a 50 or 60% chance of success. A solicitor will need to do that anyway if you're instructing a solicitor. And it will have to be a barrister, not a solicitor, probably.
But isn't that very costly if you have a small claim?
Exactly. Yeah. So If it's a small claim, forget it. It's the question in relation to a small claim then.
Well, I don't know. She hasn't said.
Well, it's good to answer questions generally, isn't it? If you've got a small claim, forget it. If you've got a big claim, you probably want to find a lawyer who will do it for no win, no fee. If you really want to be a litigant in person, and let's say it's a 50 grand claim, it's quite a simple claim, let's say, and you think the person is banged to rights, you could, I guess, go to a barrister, direct access. Some barristers do direct access where you don't need to go through a solicitor. It's usually kind of prescribed. They're not going to run your whole case, but if you just want an opinion from them, you can go to them and say, I want an opinion to get insurance. I still think it's going to be difficult though, because I can't see an insurance company bothering with one litigant in person. It's not like, it doesn't make business sense for them. They want to partner with a law firm that's doing regular no win, no fee work that they can make money on, not an unknown litigant in person. They'd probably tell that person to go and find a lawyer. And if the person came back and said, I haven't found a lawyer, they said, well, obviously you haven't got a strong case then, so we're not insuring you.
That makes a lot of sense, because at the end of the day, civil disputes are more about the money, not justice. So insurance companies are not going to care about justice per se, unless there's money in it.
I mean, yeah, it's like the cover of the book, isn't it? What's on the cover of the book?
What, flying solo?
Can you hold it up? You know, if you've got a good Spitfire, that's great. But if you have no experience of flying, you know, the Red Baron will beat you in a bicycle with a couple of wings, you know. You do need, and if you have no idea about how aeronautics work or the rules and regulations in relation to flying. So this is the analogy with civil litigation. And you may have a really good case, i.e. a Spitfire, but it's just not going to get off the ground, which is a bit sad.
Well, on that point though, can we cover both normal insurance and whether you're likely to get help from your life insurer, or if it's something to do with your house, then your whatever insurance you have to have when you own a house, etc. Like, does it not make sense to look into policies that cover your legal fees in an event that you're going to sue someone for those particular things?
That's a very good point. And the truth, technically, because you'll often get it bolted onto when you buy a house or something, you know, legal expenses insurance, it's called.
Mm-hmm.
And you think, oh, this is good. I've been sold an insurance product, and I'll get into a dispute, and well, hey, I'm going to get myself a free lawyer. Is life that cool? And what do you think? Does life work like that?
I mean, if you go to like a local insurer, then maybe you get a more personalized service. But if you go with big fish like Admiral or whatever, then I don't think they're gonna actually provide you with what you need when you do.
Yeah, because when you sit down with them, you're not going to have a conversation about legal expenses insurance, are you?
No.
Oh, can I have some legal expenses? I think I might have to sue someone in 5 years for driving their tractor into my cowshed, and I'm a farmer, and you know, that's a good idea. You've got to be a bit of a unusual character to be that geeky that you are. So the problem is, but let's say you have it anyway on your house policy. The question then is, does it work?
I can't tell you. I've never dealt with them.
I guess someone will tell me off for saying this, but no. There'll be some little catch such that the policy would exclude. There'll be sorry, you have got legal expenses insurance, but it doesn't cover you for what you want to claim for. There'll be a little exclusion. I mean, look at cars. You now have to pay an excess for the windscreen. You now have to pay an excess for the wheels and the tyres. Basically, everything that's likely to get damaged is not covered by the insurance. The insurance industry are just absolute
comment.
just much comment, aren't they? Yeah.
Oh,
I
okay,
mean,
but on this point though,
it's just so sleazy. So for that, and so that's the problem. Oh, you have to pay extra. You want legal expense insurance plus, did you? Oh, well, unfortunately, you didn't pay for that. You've got the standard version, and that doesn't cover you. And these are where the exclusions come in. They may say they cover you, but then you have to pay an excess, i.e., you've got to pay the first £3,000 of any legal insurance. Or the problem may be that you can only use a certain law firm on their panel. You can't use a lawyer you want. You can.
That actually is a typical catch. And then you find out that the law firm that you're meant to use doesn't actually cover the legal area you actually care about and need.
Agree.
And then you're, well.
And the restrictions, like your hourly rate has to be certainly prescribed, so you can't get the lawyer you want, or disbursements aren't covered. I mean, there are all sorts of little things that complicate it. Now, people must have used it, and it must work in certain circumstances. But all I'm saying is, from my experience, I have not. I've had a few experiences, not many, but I have had a few. It's always like, sorry, client, you're going to have to pay. The insurance isn't good enough.
So we talked about the costs behind.
But I'm keen to get comments on that. I mean, if any lawyers are watching and disagree with me, I'd like to know about it, because I feel I've got a bit of a jaundiced view of the insurance sector. Maybe I'm just wrong.
Well, hopefully we'll get a lawyer who deals with them on a regular basis.
Yeah.
More than you have, and we could have a lively discussion on that topic. But until then, could you quickly cover what type of costs someone may come to pay, or in a small case?
Yeah.
So let's say they go to court, sue a company, it's under 10k, and then they lose. What kind of costs are they looking at? In figures, you could.
First thing is, in time, folks, we'll get more sophisticated, and we will be able to show you on screen videos, extracts and websites and Google and things like that, so that during the course of the surgery, we can bring up information and put it on screen. But for now, perhaps, Kinga, you can have a look at my channel. There is a case, how to bring your own claim in the small claims court, a video.
Yeah.
The most recent one, there are two. There's one that's quite old, but in the most recent one, I give you that information. And I think perhaps it depends. We've got lots of questions. We've got lots of questions because
we've got free legal scenario. So
I think
on the chat question.
Thank you for that question. It's a good one. Kinga will post a link to that video on the description box of this legal surgery.
I will try my best not to forget.
Well, do it now.
I will do it now.
Whilst I'm talking.
Okay, well, I'll throw a question your way then. So general advice in this scenario. No solicitor wants to send a notice on behalf to demand notice of assignment and deed of assignment and proof of service for a mortgage transfer. Can you advise? Or would you need to represent them to know what to exactly do and say?
Not quite sure. We kind of need to unpack that question, don't we? Now, remember, folks, no more general questions. We'll make your individual dispute general for the benefit of the wider audience. All you need to do is tell us, I have a problem. I need to transfer my property from my name into my daughter's name. How do I do it? What do I do at the mortgage company? That's the sort of question we want. Not a general question about how, because it's hopeless. People don't understand this. It's like going to a doctor and saying, "Hi, doctor, I feel ill. What do you think I should take to feel better?" Well, no,
No,
he
no, no,
knows.
it wouldn't be what to take, because that implies you have no knowledge of the course of action. It would be, do you think paracetamol or ibuprofen will work best?
That's much better. You've phrased that much better. Obviously, it depends upon the exactly perfect analogy. It depends upon the condition of the patient.
Yes.
So you see how I struggle with those questions, because they're not real questions, because life is about the real detail, the nuts and bolts of what your issue, its factual basis of dispute is. And it's very dangerous, a big mistake that people make. They often get wrapped up in the law a bit too much in their cases, and they just they've kind of gone through a process where the whole way they're telling you about their case is like, so I'm thinking that there's a breach of contract here because it was an implied term that the tractor was, in good working order. And no, just tell me what happened. I bought a tractor, I tried to plough the fields, and the plough fell off. And then I went to complain, and he said, no, not giving your money back, and I'm not replacing the plough. Then I will tell you where the implied term is, what the contract is. Otherwise, you're becoming an amateur doctor and and that's a dangerous place to be. I know there's good, bad, and ugly in terms of doctors. Your job is to assess whether or not the doctor that you're going to is one that you will trust. Then you let him do his job.
That is a beautiful analogy.
Oh. So perhaps we'll move on to the next query, but in the meantime, by all means, thank you for your question, and perhaps you could put the nuts and bolts of the issue down on the chat.
Okay.
We'll bring it up next time.
I need to find that video. It's somewhere in there. It'll be, folks, in general, we have a whole general litigation and small claims playlist on the channel, and it has, let me tell you how many videos
it's playlist. How to bring your own small claim, and it'll have one of your white and red plates.
It has 44 videos which just focus on litigation and small claims, and that's really all you need. Just plow through that playlist, which I will put in the description now and on the chat, and then you're likely to find answers right there.
Yeah, well done.
And if you don't, then that probably means you should consult a legal professional. Yeah. On that note, or similar tones, what is the best way to keep up with the changes in law and procedure? How do you keep up with them?
Yeah, it's a really good point, that. Obviously, the answer is different for a lawyer, because us lawyers have subscription services which we regularly use, but they're too expensive for consumers.
Yeah, aren't they like 10,000 a month?
Reuters, LexisNexis, yeah, they're like 10,000 or £5,000 a year. Can be, but you go straight to them, and they're regularly, routinely updated. How does a consumer make sure things are updated? I think anything that's on a government website. Let's say you're looking for, let's go on to Google, and let's say you want to know what the right court fee is. Court fees are forever changing. You go into Google, you go EX50 court fees, and fees in the civil and family courts, main fees. Now, at the top of the list, fortunately, is www.gov.uk. Now, published 1st of April, last updated 18th of May 2021. See all updates as well. So you could find out by looking at that when, whether the fees have changed. So in terms of government websites, very helpful. They're always going to be up to date, and the government owns the court system. So if they're not up to date, you go to court and you say, well, you're on your own website that said that this is the most recent version of EX50, and the fee was 500 in that document. You're now telling me it's 800. Well, that's not fair. So that's the way to deal with that. In relation to law, again, it's simple. Civil procedure rules, Google that, and you'll find that, and it'll probably tell you updates and changes, but the version that's on the site should be completely up to date. Now, in terms of little interesting problematic parts of making sure your stuff is up to date. Let's, for example, take cohabitation property disputes. Cohabitation property disputes comes under the civil law, not under the family law. You've got family courts, you've got civil courts. And people think that often it is a family matter, but romantic couples who've been lived together all their lives but aren't married don't get the same legal protection. The same law doesn't apply to them as it applies to a married couple. In fact, if you've got a dispute, if you're divorced, you go to the family courts, and there's a whole set of family rules and laws. If you're all but married, but you haven't married, you have to go down the old county courts, civil courts track. Now, the government has forever coming back to Parliament. It's like, can't we make them the same law? Because it seems unfair. The couple have lived together, they've got kids, and then they split up, and there's a different law that applies to them in terms of who gets the property than if they were married. And that is a fundamentally important issue for someone who is a romantic couple not married. They want to know what the law is, and it won't be you get half because you were married. It will be a completely different legal principle to apply. Now, Parliament could at some time, I think there's even a bill, or was a bill, may change that law. So how do you, and that's not a statute that you can Google like we've just done. So then I think that probably not a bad option is simply to go and look for I mean, you know, we live in an free information age, don't we? You just go cohabitation property dispute law, and I bet you'll get some law firm, hpwsolicitors.co.uk, getting free promotion by Court Wingman. Top of the list, cohabitation disputes. You want to be looking for articles that they've written. I actually think that solicitors are probably not as good as barristers, because so you Google barristers and cohabitation property dispute law barristers, 42 Bedford Row. Barristers, unlike barristers, like to write articles. They like to be the people who absolutely know the law and they're totally up to date. So you could do worse than look for articles written by barristers. Here we've got Michael Grant discusses the recent Court of Appeal decision of Astor Communities and Kerry Chapman, 2021. So you can rely, that's going to be a pretty good place to start. A barrister's written it, you've got a date, you've actually got a case. Has the law changed within 2021? Probably not. You know, that then, so, you know, where you're looking at common law as opposed to statute law that's written, you know, that's statute law easily found. But where you're relying on common law, you're relying on judgments, and a judgment could come out. Parliament could change the law, like I've just said, in cohabitation property disputes, but a judgment could have come out last month that's at a high level, could be Court of Appeal level, could be the highest level, Supreme Court level, and you want to, you know, so you want to check the law is up to date. So I think a very good place to start is just, and you know, it's what lawyers do often, is a sort of a quick and dirty look, a way of just getting a handle, is by going to a barrister's article. So the lawyer's doing it, why don't you? So I think that is the way. Now, I mean, the Supreme Court has a website. It's not, we won't do it now, but you could, then I don't know, I can't remember, that there may be a way of checking area up, you know, searching the Supreme Court website for judgments.
There is a way.
Yeah.
You can also listen to live cases too.
Yeah.
If you want to. Okay. Going back.
Just one final thing.
Yeah.
I find, you know, just to let you know all the solicitor secrets, the barristers never do this. Oh, it'd be outrageous. But I've used law books like that law students read because they're written more simply. That's I can understand them. So you could go to either a college that's offering the legal practice course, I think it's called, for trainee solicitors, or a bar course for barristers, and get one of their books on the property law or civil litigation, and they cost about 50 quid or something, or 30 quid or something. And the beautiful thing about that is they're written more simply because they're aimed at students, but they've got to be totally correct on the law. And they release them every year because they're getting new intake of students. So that's quite a reliable source of. That's another way of answering that question. I dare say you can buy those books online now as well.
On that note, though.
Well, I dare say obviously you can.
On that note, though, if you're having to buy yourself a book on the law, then you really shouldn't be doing it yourself. I want to say, because it is very complex, and there's a reason why. There's 3 years of undergraduate study, another year on the LPC, which costs £12,000, and 2 years as a practicing solicitor to get you to do stuff right and represent people. So there's a risk there, like of doing it yourself.
Yeah, I guess really I'm talking about. I guess if there are any lawyers out there, I don't know. It might be a bit. It might be a bit heavy going. Fair enough. I think probably the best, and it's probably not gonna. The problem is, of course, it's probably not going to address your specific area of law. You know, it might be just too general. I think the best way is simply doing what I've just described. Using your Noodle, going online and see if you can find barristers' articles in your specific area of law.
Or a podcast. I think some of them have like a little podcast section on their website.
Yeah.
This is something we should be really looking into, Alex, but that's a different topic. Not
podcasts.
Just essentially take our conversations from YouTube and make them more accessible by adding them to
I was
Spotify.
looking at Joe Rogan's channel. He has now moved completely away from YouTube, and he has a load of podcasts, and he's now with Spotify.
Oh yeah, they purchased him for quite a lot of money.
So you can folks, that is the way we will go with it, because you want to be able to listen in a car, and you want to be able to listen to it when you want. So we will go with, we will get there, but right now we're just still just at the starting blocks.
We are indeed. Can we move on to the next question?
Yep.
Okay, well, Veronica has a fast track claim for a building dispute. The hearing date is set for September. She didn't include 8% interest in particulars of claim and would like to include it, as well as requesting a higher amount of money than initially claimed. Can she change the amount claimed when she submits the updated schedule of loss to the defendant before the hearing?
No, she's unfortunately, Veronica, you've got to, if it's just interest, and let's say you're a litigant in person, the judge may say, oh, you've missed it, but let's say you raise it at a hearing, or you write a letter, or you do something, and you say to the judge, I'd left interest off, do you mind if I include it in my claim? Because I don't want to go to the lengths of having to make an application just to change my particulars of claim to include interest, which is just, routinely included, and he probably will let it go. But where you're actually, and it just so often happens with litigants in person, but not just litigants in person, with lawyers, you realise you got the value wrong, or there's more fresh evidence, or events have changed. Building disputes are a classic area. We've got a building dispute at the moment, and every week there's a new reason to change the claim value upwards or downwards. If you were changing that people think that little claim value is like, well, I can change it, can't I? As we go, just get bang off the claim form and get this in front of get this in the system. Unfortunately, if your claim value is wrong or you want to amend it upwards, then the particulars of claim, the pleadings, are golden. They're like that is where your claim is. I spoke last week about the fact that the courts are now offering people a paper hearing without them being present. So the judge will be looking at the particulars of the claim, and he'll be seeing the particulars of claim, and then 2 months later he sees a letter saying, I got it wrong a bit, I want to add another £700 because he also knocked down my mantelpiece over the fire, which is priceless, 600 quid worth. And the judge is going to go, sorry, your particulars of claim doesn't include that. The only way I can allow you to have that extra £600 is if you make an application on a N244 usually, and you pay the court fee of an N244, whatever it is, £155, I think. And you have to send that to your opponent, and then you have to send it to the court, and then you have to get your opponent's agreement to the amendment. And if he doesn't agree, you have to list it for a hearing.
That's a lot of work.
It's a lot of work. And if it's on the small claims track, then maybe you just take your chances of which judge you get. Judge might say, oh, you're a litigant person, your claim form is wrong because you've given me this evidence in a witness statement that says this. Okay, I'll let you have it. But take your chances. If you get a sympathetic judge who feels your case is strong and you've won him over, then maybe. But he might say, sorry, some judges are quite geeky. You haven't applied to amend your particulars of claim, so I'm not including that change. And it may become complicated because the other side may say, well, that additional sum should have been included or should be included. And the claim form is actually kind of wrong. And they could apply to strike out your claim and force you to apply to amend it. And unless you apply to amend, they threaten they're going to strike out your claim. So it brings us back to this hoary old bit of advice that we keep on giving, which is really carefully particularize your losses at the beginning. This is why writing a letter of before action is so important, because when you write a really good letter before action, you flush out all these little inconsistencies, because when you're doing it on the hoof after official proceedings, it's likely to become very expensive.
That is correct. Preparation.
You can apply to amend particulars, and it happens all the time. And it may be in this case, the value is such that it's worth doing, but if it's low value, if it's just a low value small claim, I would just, when you exchange, I would just add that to your witness statement, and I wouldn't tinker with the particulars of claim. And hope that and then on the day say, look, Your Honour, I didn't want to waste money by making an application to change my particulars of claim, the £600 small claim. But I've since discovered in my witness statement, which the other side have seen, so they can disagree with me if they don't agree, that there is this additional £600. I'd like the court to add that to my claim value if they wouldn't mind. And I guess a judge might.
In your response, you have mentioned strikeout applications, and if someone out there i.e. you guys, want to read more about the misconceptions of the small claims, learn about the system, the CPR rules, how to think like a lawyer, etc., all of that is available in the free chapter of our book, and you can find it at book.courtwingman.com and read about that.
Book.courtwingman.com.
So yeah, it's just book.courtwingman.com. Nice and simple, free chapter, and you get to, well, have a nice introduction into what you're getting yourself into. And then maybe you'll think, oh, actually, this is a helpful guide. I'll buy the actual thing, which hopefully you will find use in it. Anyhow, on related to talking to the judge and being nice, what do you say to the judge / court to change the date of the hearing if you're snowed under? How do you approach?
Well, there is a
changing dates?
form. I think the directions questionnaire. I mean, once again, learn to become good at doing things yourself. And the directions questionnaire, and perhaps the listing questionnaire, is certainly there are forms which will ask you to give the court dates to avoid, or there will be an order asking you to give dates to avoid. So absolutely, the court does understand that you have dates to avoid. And I'm pretty sure, just having a look at the directions questionnaire now, there are different directions questionnaires depending on the different tracks you're at, you see. So, do you want a 1 month stay? Which county court do you prefer? Usually the defendant can elect to have it sent to their home court. Blah, 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 blah. Case management information. Have you made any applications? Track, disclosure. I can't see. I thought there was a section. I mean, I should know really because I look at these documents all the time. I think that the directions questionnaire doesn't allow you, because it's really too early on for the directions questionnaire too. But if you are filling in a listing questionnaire or pre-trial checklist, which occurs before the actual trial to prepare for the actual trial, the directions questionnaire is like the document that you use to prepare the case immediately after the statements of case, the claim and the defence have been filed and served, and then you fill in the directions questionnaire to manage the entire proceedings. The pre-trial checklist or listing questionnaire, two names of the same thing, are what you do to prepare for trial, the trial itself, if you ever get that far. And there they will ask you to put down dates to avoid. So in the case of the questioner, maybe they've not got that far down in now, what if it's a hearing, just a little hearing that's being listed along the way to trial and you can't make it? Well, what you would do is you would say to the other side, I've got a problem with this date. Can we vacate the next available date? And you would then need to send a letter to the court or a consent order if you're being totally belt and braces, asking the court to vacate the hearing to list it for the first available date, and perhaps putting in the covering letter, well, no, not perhaps, definitely putting in the covering letter the dates that the court should avoid. That's if the other side disagrees with that. It's a good question. I don't really know the answer to let's say a 30-minute preliminary hearing. If the other side don't want it moved, can you get it moved? Well, I guess if Probably just needs your common sense. If it's your father's funeral, I think you would write in and say, we think it's unreasonable. The court is listed this on a very key date for me, and the other side are refusing to have the hearing date moved. Can it be vacated to the next available date? I think the court would accept that. But generally, courts do not like, just because you can't make it because you're going on holiday, to move hearings around. And this day and age, more than ever, when things are online, so you could always log in online. Most hearings are online. What excuse have you got not to make a 30-minute hearing on a Wednesday? 4 hours of 10 to 4 weekdays. Also, you can appoint a legal representative, so or not someone to go to court on your behalf. Yeah, a legal representative. So the court's like, well, you can make other arrangements. So it would be quite, or it may be that you could agree that this hearing isn't really very critical, and that you talk to the other side. It's just a hearing to deal with track allocation or directions questionnaire or whatever the issue is, or an expert witness or something. You could just talk to the other side and agree that it's not really needed, and then together you jointly, this is what a lawyer would do. There's no reason why a litigant in person can't do it. It's the same rules for them as it is for us. Do a consent order where you say it has been agreed between the parties that the case will be allocated to the fast track. We would like the court to agree that a building expert is allowed. We think the trial is going to take one day. And then both parties sign it, send it into the court, and hopefully the court will then vacate that hearing. So you'd have got the business of the hearing done on paper.
So the person asking the question says it's a listed hearing in person and 4 hours have been allocated to it.
4 hours, so it sounds like a trial.
Mm-hmm.
So she should have already got. I wonder whether they were asked, and she wants it moved because she can't do it. I guess you better have a good reason, and you better get the agreement of your opponent.
Well, what if they don't agree out of spite? In that they could do a different date and they could be nice and reasonable, but they go, actually, no, I'm just going to annoy you further.
Well, if they're doing it out of spite, you write to them and say, there's no reason why this trial can't be moved. I've got this very good reason for moving it. Okay, it's just I'm getting married on that day. You won't move it. I'm putting you on notice that I'm now going to have to apply to the court for a hearing to deal with the sole issue of moving the hearing, which isn't prejudicing you in any way or shape or form. The delay isn't going to prejudice you, let's say. I'm assuming it's not going to prejudice them for whatever reason.
Mm-hmm.
Then if there's no prejudice caused to your opponent from vacating the hearing, then there's no reason why they should object. This same principle comes up a lot in where people need extensions to file their defense. They need an extra 28 days on top of the initial 28 days. Now, most lawyers would just agree because they know they get the system to an extra 28 days. What's a month in the life of civil litigation? Quite a short period of time. Yeah. But lots of spiteful opponents would just try and throw a spanner in the works. Not even spiteful, you're just being competitive and aggressive. What you then do in that case, because this happens more often than the lady's example, is that but it's the same principle. You say to the others, well, look, we can't see give us a good reason why this can't be, how is an extra 28 days going to harm you? And we want that in writing, thank you very much. And if you don't provide this in writing, and if you don't agree to give us an extra, we're going to make an application to court. We're going to get this in front of the judge, and when it gets in front of the judge, we're going to say, this is a whole big waste of time, Your Honour, because the other party could have agreed to this. It's not prejudicing them. That's the way you handle it. And then the judge will say, if there are any costs occasioned by that hearing, let's say you sent a lawyer, then the judge will say, yeah, and he will order costs against that other party for just being obstructive for no good reason. You know, at the end of the day, use your common sense, actually. The judges are human beings, nearly. So, I mean, if you've got a wedding on a day, or, you know, you've been isolated for 18 months and, you know, you need to go to a hospital appointment or something, then always try and seek the agreement of your opponent. Be very calm, relaxed, professional. And if they are being obstructive, then you say, well, okay, this is you want this? Well, we'll take this to court. Do you really want to waste time and money and get a rollicking from a judge because you're not agreeing to a reasonable request that I've just made? And people forget that you actually need to take off the, you know, put down the weapons and have a little white flag truce when you're dealing with case management issues like this. You know, it's like, okay, fine, take the gloves off and we just need to sort out this case management problem, and then we put the gloves back on and knock the hell out of each other. But for those sort of case management issues, the court expects you to be cooperative.
That makes sense. On that note, if the defendant, another question from a different person, just saying, if the defendant ignores my dates to avoid and gets a judgment, can I apply to set the judgment aside pursuant to CPR 3.6 brackets 3?
Yep, you can get judgment set aside. It's not as final as you think it is, judgment, providing you do it within providing you haven't sat on it for a year or 6 months, you know. But providing that a genuine error has been kind of made by you, but that you realise, oh, damn it, I wasn't able to attend for whatever reason, then yeah, but you do have to make an application. It's then not simple to set aside judgment, but it can be done if it's done promptly. I can't remember what the rules are, but you'll find that your question is probably answered. I mean, again, guys, you can do worse than Google. What, you know, setting aside judgment, CPR, part 13, it says. This is default judgment. Setting aside actual judgment itself is an appeal in effect. But let's say this is a default judgment. I'm not sure which this is. Then you'll see the criteria that you need to comply with in order to get over the wire, get over the line.
That's good advice.
In considering whether to set aside or vary a judgment entered under Part 12, the matters to which the court must have regard include whether the person seeking to set aside the judgment made an application to do so promptly. So I've been in a lot of little hearings like this in all sorts of different areas, but often where you are applying for relief from sanction, where you've breached a court order. And you've got to apply because you've breached a court order, you haven't served a witness statement in time, now it's quite late, and now you have to apply to allow your evidence to go in. I had to make one in a case, we've got a conflict, cost proceedings recently, and one of the absolute yardsticks is, have you acted promptly after realising that, you know, that some error has been made by you? There will be other criteria, but we don't have time to go look into it. But for the geeks out there, it can be a bit difficult reading the CPR. It is complex, but it can be done. And for the geeks out there, you could just Google the criteria of setting aside judgment CPR, and you'll come up with the relevant justice.gov.uk reference. If it's a final judgment, the trial, then you're looking at an appeal of some sort, or needing to talk to a lawyer probably, because it's such a fact-specific situation. You know, if someone had a massive car accident on the way to a trial and they missed it, and then they wake up out of hospital from a coma 2 months later, that's a different situation, isn't it? To, oh, I was on holiday, I missed the hearing and I forgot. So you'd need to give more. Again, that's sort of a general question, you see. And the problem with general questions, you don't get the advice you need and want. You get general woolly answers like the one I'm giving you. And you go away thinking, because it's not absolute. It depends entirely on the facts of the case, what the criteria are. You know, if you could give me the detail in these questions, then we really can give you much better tailored advice.
You could always come back to us in 2 weeks' time for another YouTube live. Fill out the form in the meantime, and or jump on the call with us, and then you'll have 30 minutes of free legal advice only in return for your voice. And that's a requirement, because everything else can be changed. We are at the end. Actually, we went over this week. So this is the official end of this live. Do click subscribe, do hit the like button, leave a comment, because it does help us climb the ranks on on YouTube, and show up for the people who also need legal advice but simply don't know about Court Wingman. And then if you want the book, then go on to our new website, courtwingman.com. Or download the free chapter at book.courtwingman.com. Do bear with us with the website. It is brand new, and we're making changes to it as we change from the legal setup and Redwood Legal. And if you do have any feedback or suggestions or what you would want to see on the website, then do email us, because your feedback is very important. We're also thinking about launching a webinar series that will be available on the website, where you can essentially go along the advice from the start of your process to the very end and trial. And if there's any specific topics you would want us to cover and you think would be useful for people like you, then do let us know, because that is simply invaluable feedback.
Just to clarify that, it's not so much a webinar interactive thing. It will just be a series of
it's more like do it at your own time. Yes. Sorry for not being very clear.
With maybe some documents, we haven't quite finalised that, and templates or something, and specific advice and links and so on and so forth to deal with particular phases of litigation, particular issues. You mentioned Redwood Legal. So Redwood Legal is closed. It's not actually completely closed, but it's not trading any longer, as it were. Court Wingman is the fresh new legal service that we are now providing and putting a lot more work into. And it is not a law firm. We can provide a lot of help to you, but we can't represent you in court. But we can provide far more cost-effective and competitive help to you, actually, by not being a law firm and just offering paid legal services to you, such as drafting documents or giving you advice, and so on. We can probably even actually appear at hearings. But if you do need full representation, you then have to come to us at South Bank Legal, where myself and Diane Sitkovska have moved as consultant solicitors. But a lot of these queries are just, you're probably thinking, do I want to put my hand in my pocket for £150? That's the rate for a 1-hour legal surgery with Court Wingman. But a lot of these queries will be cleared up, and you can be given full and proper answers by booking up a legal surgery. They're really quite useful. I mean, because people provide the documents which you can look at online during the call, and on Skype we can share the screen, and we always give you more value for money, and we try and get you some advice that you need, even if it slightly runs over the hours. So I do think legal surgeries are a very good way of getting a handle on your dispute.
And it makes it more accessible to people who don't have big budgets, essentially.
You can get quite a lot out of a legal surgery, actually, with a reasonably experienced lawyer. Even if it's only you're wasting your time, and then you've saved a lot of time and money.
Well, no, they are very useful. And I mean, the only reason you're not a law firm anymore is to be able to offer more.
Yeah, because actually it's just not, you can't run a law firm on £150 an hour legal surgeries.
No.
So that's why they're not interested. The law firm's not interested in giving you a 1 hour £150. It costs them that much to open the file and raise the invoices and do all the paperwork and fit in the retainer. So it's just not. But for us, it is something we can do. A lot of legal surgeries have become really a bit like Citizens Advice Bureau, except plus extra, because we can look at documents with qualified lawyers and we tailor the advice to your case. Citizens Advice Bureau is generalist, isn't really able to tailor the advice to your case in that way. So I think it's a really good initiative, and I think the legal services sector in this country needs reform. It's like opticians. There was a day when you had to have a special optician certificate, and you remember the old, well, you're too young to remember, but you used to have a set of spectacles outside the village opticians, and there were regulated professions, and you can only get your glasses from an optician. And then it all changed, it was deregulated, and then anybody can go to Specsavers and buy a pair of the same ones for 50 quid, or well, 15 quid. So the whole, that sector, that was deregulated in that way, and it meant that competitive service could be offered. Now, some people need an ultra-traditional eyesight test. You don't exclude that sector, but obviously a lot of people don't want that. So it was a good evolution. And I think a similar thing may well, if it's not already happening, to the legal sector.
Probably. Well, a lot of high street law firms are closing.
Well, that's the trouble. They can't. It's sad. Conveyancing firms, they can't make any money. Everybody wants their conveyance done for a pittance, and yet it's an incredibly risky business if you get a house conveyance wrong. And so you've got this huge amount of red tape. So yeah, it's not easy for the high street.
Well, if someone can't afford legal advice, at the end of the day, that's why we do this, right? So they can either submit questions in the chat or fill out that form, jump on the Zoom call, share their voice, change all the personal details if they're worried about confidentiality, and then just get some legal advice or general pointers specific to their case in the 30 minutes on here, whilst helping everyone else who might have a similar problem.
Exactly. So I mean, that question last week was very good about a building dispute, because it helped construct a good whistle-stop tour of how to deal with a building dispute in the county courts. I mean, I think we would like to extend this to 2 hours and once a week, but right now we're not got enough capital to start doing that often that sort of service. But it would be quite good to be able, because it does need more time, doesn't it, Kinga? The hour is really quite short.
There's so much research that goes on, like so much research and background tasks that happen before these two, and it takes double the time really to run even just one session like these, and obviously you have to get yourself nicely prepared too. You can't just sit here in pajamas if you're working from home.
This isn't an accident, no.
Get equipment, so on and so forth. So yeah, it does. Maybe we should do a little sponsor.
Do you think anybody is still listening at this point?
Yeah, there's people actually here listening to us. Thank you so much. Maybe we should have a little donate button, so whenever someone gets an answer from this session, they can donate an amount that they're happy with via the website.
That would be cool, because you could then justify commercial value of doing 2 hours.
Well, it would pay for itself. it would pay for itself
Yeah.
essentially.
Yeah.
So yeah, maybe. I mean, what do you guys think? Is that a fair deal? You get to then go on the website and be like, oh, actually, I'm happy with this answer. Let me give you £3.
That would be quite interesting.
These
I
things
think
actually
people,
happen.
yeah,
They
I think
really do.
deep down people do want to give, don't they?
Yeah.
If they get good service, but they want to get good service too, and they're a bit fearful out there of what sort of service that they're going to get. Yeah, wouldn't it be beautiful? We lived in a world where the person just gave the good service, and the other person felt that's good service, I'm going to give them some money.
Uh,
You know.
no, actually, that happened yesterday. So I got some wardrobes for my little one's room, and they use off marketplace, 20 quid. And I was like, oh, could you deliver to my house, please? Because I don't have a car to go and pick them up. And she was like, yeah, no problem. It would be there would be inconvenience. Obviously, she has to load it in her car, then waste petrol, waste her time. So it comes to like an hour of extra time that she's giving to me. So she gave me the price that I need to send her, which was just for the wardrobe. And I was like, nah, I'm just gonna give her a little bit extra for the inconvenience caused by the fact that she has to go out her way and and deliver them to me. So yeah,
people do. That's a great example, but people do. I think naturally, deep down, I think we do want to help other people and give. It's just that society has, the world presses in on us, and we don't go with those natural impulses so often. It's like when someone drops something in the street or something. And, I was in Belarus a month ago, and I couldn't find a shop, and a guy, a local, took me all the way to the shop, and then helped me buy what I needed to buy, and then said, "Look, do you want a coffee? I want to do an interview for my documentary series. You happy to do that?" And then he insisted on paying for the coffees because I was a foreigner from a different country. Really, really neat.
That is very nice. Someone just said that YouTube takes 40%. I guess you're referring to the commission once you monetize your channel. We've made the decision to not monetize our videos, although we do have the possibility. So the moment we hit 1,000 subscribers, we were obviously given the option to monetize on our videos, but then thought, actually, why interrupt the videos and the advice you're getting and waste your time with ads? For the pennies that they give us.
Well, because then you're just going back to living in the world of television, aren't you? Commercial television, where you just got ads. That's what YouTube are doing now, I've noticed. We had one video that had 18,000 views, and now when you watch it, they just randomly cut to a commercial break.
Yeah, that's what
ruin the video.
Exactly. So we made the decision to not do that. So hopefully that is some proof to you guys that we're not about the profit. I mean, it's nice to make a living so you can live in a house, pay your bills, and go on holiday once a year, or once every 2 years, or once every 3 years. But yeah, we're not greedy.
Well, we are there to make a profit, but I don't think the things are mutually exclusive.
Exactly.
Offering a good service, because actually, people, will start giving or paying where they're getting a good channel and a good service. Anyway, we should probably draw it to a close, shouldn't we?
Yeah, well, I already did my close like 10 minutes ago before we started this conversation.
All right, folks, so if you're still here, thank you for just sticking with us to the bitter end. Look forward to seeing you in a fortnight's time.
Yes.
Bye for me.
Bye-bye.